Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to circle back now to cases that are asking to be reviewed by the United States Supreme Court. We have been through this many times, and we know that trying to figure out what the Supreme Court is going to do is virtually next to impossible. For all the pressing issues that we have out there, magazine bans and assault weapon bans really being at the top of the list, today's issue is going to be a case that was actually filed some time ago, but suddenly seems to be picking up a lot of steam. And it has to do with a platform of firearms that many would call dangerous and unusual, but the truth of the matter is there really is nothing unusual about these firearms at all anymore. So today, let's get you all educated and let's talk about, is the Supreme Court really going to take an SBR case? Okay, America, the case we're talking about, and we have talked about this case before, is the matter of Robinson versus the United States. It comes out of the 11th Circuit. It is now on petition to the United States Supreme Court. Now, there's a big brouhaha brewing around this because there has been a docket entry where the United States Supreme Court has asked for the Department of Justice to weigh in on this because they'd like to hear what their response is. Does that mean that suddenly the United States Supreme Court is going to take this case? Oh, God, no. I mean, didn't we spend the whole springtime and part of the summer together every Monday morning waiting for the orders list to come out to figure out that Snope v. Brown and Ocean State Tactical was eventually going nowhere? Yes, we did. So again, take this for what it's worth. Now, this is what I want you to be aware of, though, because there is at least a little activity going on with this case. Obviously, Robinson was convicted of possessing a short barrel rifle, which was not registered with the NFA and therefore subject to criminal sanctions. He appealed. It went all the way to the 11th Circuit. He was unsuccessful in appealing. The petition for certiorari before the United States Supreme Court was filed on July 18th of 2025. Our good folks over at the Second Amendment Foundation filed an amicus brief on August 12th, 2025. So at this point, things are just kind of moving along in a rather normal fashion. However, there is a docket entry that was now entered by the United States Supreme Court on August 20th, which reads as follows. Response requested, due September 19th, 2025. What does that mean? What it means is that the United States Supreme Court has reached out to the United States Department of Justice and said, hey, we kind of need you guys to weigh in on this one. Now, does that mean that they're going to accept review of this case? Absolutely not. But it does mean at least that the opening petition, as well as the amicus brief that was filed by SAF, has at least raised the interest of a handful of judges on the Supreme Court, and therefore they are asking for the United States Department of Justice to reply to the initial pleadings filed in this case. And on top of that, this case has already been set for conference on September 29th later this year. Now, again, we know that just because something is set for conference, hell, just because something is set for conference a dozen times, does not mean that that's going to get us to the promised land, but there certainly is at least a little bit of activity and interest circulating this case right now. So, what does this case stand for? What is it all about? Well, the issue presented, according to the petition for review, states the following. Petitioner David Robinson Jr. was convicted under 26 U.S.C. section 5861D, 5871, and 5841, sections of the National Firearms Act that impose criminal penalties up to 10 years imprisonment for possessing a short barrel rifle not registered by the transferor of the rifle. As the transferee, Robinson was not responsible for paying the $200 fee required to register the rifle. The constitutional foundation justifying the federal criminalization of his conduct is Congress's power to tax under Article 1, Section 8, Clause 1 of the Constitution. The important federal questions presented are, and this is where I want you to pay attention because we know that there are other challenges going on right now with the NFA, all done post enactment of the big beautiful bill where we now have removed that taxation or taken that taxation down to zero. This is a unique challenge that actually predates anything through reconciliation. So the issues presented here are Number 1, whether federal criminal punishment of the possession of an unregistered short barrel rifle violates the Second Amendment. 2, whether federal criminal punishment of the possession of an unregistered short barrel rifle exceeds Congress's power to tax under Article 1, Section 8, Clause 1 of the Constitution and violates the 10th Amendment. So unlike the other arguments that we've talked about on this video right here, which is now that, hey, listen, Kaczynski says that all of these records were necessary for tax-keeping purposes. We're not taxing these platforms anymore, and therefore this exceeds the scope of Congress's authority to regulate this. This one is more based upon that the NFA, standing alone, taxation or otherwise, exceeds Congress's authority and violates the Second Amendment. Now, I believe that there is case law out there that probably makes this argument a little bit more difficult than the petitioners may want. However, between this and some of the other lawsuits that we're now seeing filed on the NFA, based upon these items going down to $0 taxation, it is very obvious that over the next 12 to maybe 24 months, the NFA is going to get a serious look at by a lot of district courts and ultimately could be examined by the United States Supreme Court as well. Will anything come of this? God only knows. This is the United States Supreme Court. It's been absolutely impossible to try to predict what they will do. But we do know that the government's response brief is due on September 19th, and it is scheduled for conference on September 25th. We will circle back to this issue when that time comes to keep you educated about what's going on with the case. The case, once again, is Robinson versus the United States. We're going to go ahead and link up the original petition down below so you can geek out on it for yourself. You don't have to take our word for it. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.